court appearance Monday, as there are some new details that are emerging in the case against the other 3 officers at the scene of George Floyd's death.
Attorneys for 2 of the former Minneapolis officers rejected accusations that their clients aided and abetting the killing of Floyd, casting blame instead on senior officer Chauvin, who allegedly ignored his younger counterparts.
Well, joining us right now, Katie Fang, the attorney and MSNBC legal contributor, and Enrique Latoison, who is a criminal defense attorney. Welcome to both of you.
Katie, we'll start with you. One of the former officers, J. Alexander King, hadn't yet completed his 3rd full shift as a police officer when this arrest occurred. According to his attorney, he told fellow officers as they were detaining Floyd, quote, "You shouldn't do that." And another one of the officers, Thomas Lane, was reportedly working his 4th day as a full-time officer when this occurred. His attorney telling the court they're required to call Chauvin sir. He has 20 years experience. What is my client supposed to do but to follow what the training officer said? Is that much of a defense?
Well, it's certainly a defense, but remember, you have to keep it in the context of when those words were provided. These were done at a bail hearing, so the bond for those 3 officers that were charged with aiding and abetting former officer Derek Chauvin has now been set at $1 million, conditionally at $750,000. And so the defense attorneys are going to say our clients didn't actually assist, help, or abet Officer Chauvin when he was committing unintentional second-degree murder. But the challenge to whether or not that aiding and abetting charge will survive will come in the form of a motion to dismiss, which is predictable. But there has to be an accountability here for the actions or perhaps the inaction that was taken. And I hate to say this, but we've heard this before, haven't we? Historically, we heard, I was just following orders, or I was just doing what I was told to do. And that has never resonated historically in terms of culpability and escaping culpability. So let's see whether or not a motion to dismiss, well drafted and argued well, will actually help them get out of this aiding and abetting charge.
Yeah, let's talk about one of those cops, one of the suspects, Thomas Lane, his attorney speaking out. Do we have this? Let's play it.
No, I'm not claiming he was following orders. I'm claiming that he thought what he was doing was right because he asked the training officer, should we roll him over twice? You got to have criminal intent for second-degree murder. And frankly, this is bull.
He has a way with words. Enrique, does the elevation, you think, of the murder charge make the case more difficult to prosecute? We're talking about the elevation of the murder charge when it comes to Chauvin himself, actually.
No, I don't think so at all, not in this particular circumstance. I mean, when you look at the video, the most disturbing part of the video, I think, is the officer standing there looking down at Mr. Floyd. He's watching, he's looking very carefully. He's looking at him the entire time that his knee is on his neck. It's also very important to remember they had already called for medical help. It was already known that Mr. Floyd was already in medical distress at that time. So what you do when someone's in medical distress and you've already called for paramedics, they have the training. The training is to make sure that Mr. Floyd is safe while you're waiting on that treatment. Instead, what this officer did was he kept his knee on his neck the entire time, not moving his knee until the EMT basically came over and took him off of Mr. Floyd. So, you know, the assault was taking place. That was an intentional act. And by that being an intentional act, this was then, therefore, a second-degree felony murder because the intentional act was the assault. And then, therefore, the unintended act caused the death of Mr. Floyd.
Katie, I'll pose a similar question to you. We've heard over and over again from legal experts that prosecuting officers is a very difficult task. Do you think that by elevating that charge from third-degree to second-degree murder for Chauvin, aiding and abetting to second-degree murder for the other officers, do you think that that will make their case more difficult?
Actually not. From a substantive legal standpoint, it's easier to prove second-degree unintended felony murder than it would be third-degree murder, which were the original charges. I think what's going to happen here is you're going to see a severance of the other officers from their cases from the main culprit, which is Derek Chauvin. You're also going to see an attempt to change the venue in this case, although that's going to be a virtual impossibility. How are you going to find a jurisdiction or a new place that hasn't heard about the George Floyd murder and hasn't heard about what these cops cops did. I think you're also going to see something, too. If it survives, like we talked about a few minutes ago, a motion to dismiss, you're going to see this guilt by association that happens when you present this type of case to a jury. But we do have an increase in exposure of police brutality and police misconduct. And so I think that because you've seen an increase in the visibility of pulling the layers back and showing how the system has broken down, it's actually not going to be that difficult to be able to get the convictions that you need.
Well, that change of venue plan worked successfully for both the cops in the Rodney King and Amadou Diallo shooting here in New York, and no doubt they will try to do it again in this case. Katie and Enrique, thank you both.
New response